Mama, we made it. We went shopping, our offer was accepted, we wired the deposit, and bam! Escrow drops a big motherfucking stack of papers on you, and one of them is titled vesting. And like most buyers, you're looking at it like, which is all right, because in this video, we're gonna cover vesting, or in other words, the 4 most common ways to hold title to your property. Disclaimer, I am an attorney. However, this is not legal advice. When I'm sitting in this yellow chair, I am your realtor giving you legal information. So I highly advise you to reach out to an estate planning attorney and talk to them about the specific circumstances of your case. But with that out of the way, let's break into this bitch. Let's start high level. Vesting is simply the legal term for the manner in which that you hold title to your property. But the way that you hold title can definitely have an effect on the way that you transfer that property and what happens when you die. Vesting type number 1, sole ownership. If you are a single man or woman, one way to hold title is in your name alone. This might be the way a married person takes ownership if, for example, they are investing in real estate as a business, totally separate from anything that their spouse is involved in. Generally speaking, if you're in a state like California or Nevada that recognizes community property laws, your spouse will have to sign off on a quitclaim deed, relinquishing all their marital rights to that property. Holding property in the vesting form of sole ownership doesn't really provide much of any tax advantage, but it does expose the property owner to the probate process when they die. Because we're going to hit the topic of probate a couple times today, let's just touch quickly on what this means. Probate is a Latin term that simply means to test or approve, and it is the judicial process in which a person's will be proved to be a valid legal instrument. And when a person doesn't have a will, probate is the process in which the court decides who and to where all your shit is going. Probate is expensive, and it fucking takes a while to go through, which is one reason why people are really trying to avoid having their family members go through that process. Vesting type number 2, tenants in common. This is the sort of way that 2 or more owners might take title to property, especially in a place like California when those people are not married. For example, 2 real estate investors or compadres or friends might want to take title as tenants in common. As tenants in common, each person has a specified interest in that property, but it does not have to be equal. For example, you could have one person own 10% and another own 40%, with the last person owning 50%. It really doesn't matter what the breakup is, so long as that specified amount of ownership is designated in that property's deed. It is important to note that each tenant has the right to use and enjoy the whole property, even though they might not own the whole thing. One major advantage with this type of vesting is that each tenant in common can sell or pass their interest in that property to whoever they want. This is popular with second marriages, for example, because spouses might want their interest in property to go to their kids of a prior relationship. This type of vesting, though, can be a double-edged sword depending on what side of the coin you're on, because in one sense, this shit is totally freely alienable for you to give to whoever you want, but if you're that remaining tenant in common, you might own this bitch with a complete stranger, like the Karen next door.
A neighborhood name calling in West Sacramento. A mother so fed up with complaints about her kids, she posted a sign outside her home saying the street is full of Karens.
Vesting type number 3, joint tenancy with right of survivorship. When title is held in the form of joint tenancy with right of survivorship, each owner must take title at the same time and own equally each share of that property. One thing that really separates joint tenancy from tenants in common is what happens when somebody dies. As a joint tenant, the surviving tenant, the person that did not die, receives the entire dead person's share of the property, and that dead person's will has no effect on the joint tenancy. I'm not advocating that this be someone's estate plan, but this is sure as shit one way to avoid the probate process, because when the property is transferred to the surviving tenant, it avoids the whole process of the court being involved. One major disadvantage with joint tenancy is that owners cannot pass their interest in the property to another person without the permission or approval of the other joint tenants. And in the event one person goes behind another joint tenant's back and does some back alley, shicey transferring of the property, the joint tenancy is extinguished, and as a result, a tenancy in common is created. Vesting type number 4, community property. Community property is a special one, and it is only available to a husband and wife in states that recognize community property laws like California, Nevada, and Arizona, just to name a few. In this form of vesting, each spouse owns 50% of the property and can will away their share to anybody they want, like the pool boy.
Hey, Miss Handler! I found a dead squirrel in your pool!
Or their surviving spouse. The special advantage of community property is what happens when somebody dies. The IRS provides that the surviving spouse receives a new, stepped-up basis at market value to the date in which the deceased spouse passed. To put it simply, the step-up in cost loophole allows the surviving spouse to minimize the amount of capital gains that they might be exposed to, and ultimately, the amount of taxes that they'll have to pay. Overall, each type of vesting has pros and cons, but you should definitely consult an estate planning attorney to set up a living trust or some sort of instrument that best protects you and your family. This is definitely one of the more complicated topics, and even after 3 years of law school, it still has me scratching my head sometimes. So please, share this with someone that you know who needs to hear it, and I really hope that you took something away from it. As always, thank you so much for watching. I'll see you tomorrow.